Okay, well, I think we should probably get underway now. It's 5 past. Thank you everyone for joining today for the Insurance Masterclass on D&O insurance, construction, and prosecution risks. Apologies first of all if you were expecting to see Stephen Reilly. Unfortunately, Stephen's not very well, so you're stuck with me, I'm afraid. I'm Nathan Penny-Larter. I'm a senior associate here at Beale & Co. And I do a broad practice of D&O together with professional indemnity, particularly with a construction angle. This seminar will look primarily at risks which might face directors and officers and other employees arising out of the post-Grenfell Tower fire landscape, and particularly looking at and focusing on the risk of prosecutions. We have the pleasure of the company of two eminent experts in this area. Firstly, we have Simon Antrobus, QC of Crown Office Chambers. Simon has over 20 years experience as one of the leading barristers in this field of criminal regulatory law. He's worked on some of the most high-profile health and safety cases this country has ever seen, including the Buncefield oil terminal explosion, the prosecution of Merlin Entertainment, the owners of Alton Towers, which followed the accident on the Smiler roller coaster, and the prosecution of the health and safety officer for Sheffield Wednesday Football Club following the Hillsborough Stadium disaster in 1989. He's also currently representing ITV in connection with the suicide of a guest on the Jeremy Kyle television show, and the Arcadia Group in connection with the death of a child at a Topshop store in Reading. So we're very lucky to have Simon with us today and the benefit of his expertise and experience in this area. And our second speaker is Joanna Lewis. Jo is a partner here at Beale & Co. And as well as handling construction professional indemnity claims, Jo's an expert in advising in relation to health and safety and regulatory law. She advises on all aspects of investigations and prosecutions, including what to do after an accident, coroner's inquests, regulatory offences, sentencing, and insurance cover. In fact, Jo has recently just been named as in this year's Legal 500, recently published Legal 500, as a leading individual in health and safety law. In recent years, Jo has acted on the acquittal of a corporate manslaughter prosecution in the Crown Court, and Simon and Jo are both acting on the public inquiry into the Grenfell Tower fire. As I said a bit earlier on, my name's Nathan Penny-Larter. I'm a senior associate here in the team here at Beale & Co, and I advise on in relation to the defence and coverage aspects of claims against directors and officers, mostly in relation to commercial D&O, and I also advise on professional negligence matters, particularly against architects, engineers, and other non-construction professionals such as solicitors, accountants, and brokers. So looking at directors and officers, claims against directors and officers are ones which are growing and causing increasing concerns for insurers. The statistics in this area speak for themselves, really. The premiums for D&O insurance, according to the source that I saw, grew significantly in 2020 as demand grew and companies faced elevated levels of litigation. In 2019, premiums rose by an estimated 19.7%, and in 2020 they rose by 40.9% in the UK. The trends with D&O tend, using a crude rule of thumb, to follow the major news stories. So we've seen increased claims arising out of the #MeToo movement and equality issues arising out of the BLM movement. We also expect to see rising claims from the COVID pandemic relating to the return to work protocols instituted by the boards of major corporations and smaller corporations as well. Insolvency administrations looking to recoup losses from the directors of companies, and also the move towards more heavily regulated climate change legislation, which is on its way and is increasingly in focus due to the very topical and ongoing COP26 summit in Glasgow. The other major risks presented to directors and officers are those arising out of the tragic events of Grenfell Tower in June 2017, and that is the focus of the presentation today. We'll look at broadly the following issues, and they're up on the agenda on the screen. So the safety legislative framework and common HSE and criminal offences potentially impacting senior managers, partners and directors in place leading up to the Grenfell Tower fire. The HSE's and the police's pre-Grenfell approach to investigating and prosecuting offences and the changes we have seen since Grenfell. Typical D&O insurance issues, insurance gaps arising out of such issues, and how to keep protected as a senior manager, partner or director. And a review of the evidence heard in the Grenfell inquiry and the potential for HSE and criminal prosecutions coming out of Grenfell. And also touching on what the future might be for individual accountability of senior managers, partners or directors after Grenfell, and potential legislative changes to increase individual responsibility. We won't necessarily deal with them in that order. We intend this to be more of a discussion, and if anyone has any questions throughout, please type them into the box, which I think is relatively user-friendly. And if they're appropriate to answer during the course of the talk, then we will do so. Otherwise, we've got some time at the end of the talk to be able to answer those questions. So please feel free to put them in the box whenever one comes to mind. So I think if we move on to the talk now, dealing with the second of those broad issues first. Simon and Joe, can I ask you, have you noticed much of a change in terms of the approach of the police and the HSE post-Grenfell in terms of the attitude towards prosecuting directors and senior managers?
Well, if I jump in first on that one, I mean, anecdotally, yes. I mean, it's my experience and that of a number of my colleagues from chambers who practice in the same field that prosecutions of directors, senior managers have been on the rise for the last few years, and certainly since Grenfell. Now, whether that's, I don't know, whether that's the direct consequence of Grenfell, the public outrage at the inquiry, I'm not so sure, but there's definitely a Grenfell factor at play here. I mean, even if it is in operation with others. I mean, my take on the way that the police and the CPS have approached matters since Grenfell is that there's certainly much more of an appetite to investigate in a more hostile fashion the responsibility of directors. But I was just thinking about this, Nathan, because in terms of trying to think what my answer would be to that particular bullet point, it struck me that you've kind of almost got to go through a kind of historical trend here, because what happened in the aftermath of Grenfell and the approach that's being taken in the aftermath of Grenfell just fits, I think, with the way that the approach of the prosecuting authorities has changed over time towards directors and managers and the like. I mean, I remember back pre the Corporate Manslaughter Act, and there were very few prosecutions of corporates or directors, very few indeed. The police and CPS really weren't interested, and the ones that they did run usually failed. Hence, they brought in the Corporate Manslaughter Act to deal with the corporate side of it. But interestingly, when the Corporate Manslaughter Act came in, the way that the police and the CPS prosecuted the early cases was that they felt rather uncomfortable about just prosecuting a company on its own. They felt they had to also have the senior managers there, or the jury wouldn't get it. And so the first few prosecutions were just this kind of scattergun set of prosecutions where you had the company, you had a number of senior managers, all separately represented. And I remember being involved in one of those cases, Lions Steel, where halfway through the case, the end of the prosecution case, the case against my client, one of the directors, fell over completely, and there was a submission of no case to answer. And then the prosecution had to really go to the other directors. That they all got out in response for the company taking a plea to corporate manslaughter. And that then developed as a bit of a trend. So there were a number of cases which all just fell over in exactly that same way. Individuals get out and the company takes a plea to corporate manslaughter. And after a bit of a run of these, I mean, it was costing the public purse quite a lot of money, failing in these prosecutions, that then the CPS suddenly started having a bit more confidence in prosecuting companies on their own under the Corporate Manslaughter Act. But then the problem they encountered there was that these often turned out to be rather Pyrrhic victories. They'd prosecute the company. Very often they were tiny companies anyway. The fine wouldn't be enormously high, or not much higher than a Health and Safety at Work Act fine. And actually, at the end of it, I think the question was, and it was sitting in the minds of the prosecutors, as to what was the value of that if the key players in that company weren't in the dock as well. And so the trend then started to move, and it seemed to me to coincide also with the Grenfell Tower disaster, that then suddenly there was this trend to actually try and get a bit more accountability going. And I think Grenfell has really played into that, because such was the shock and outrage that something like that could happen in this day and age in this country, that and with the inquiry and the extent of the inquiry and the way people have been grilled as part of the inquiry, I think that has just brought into that trend that was already happening anyway, but has really accelerated it. And that's definitely the experience now that I'm seeing a raft of these types of prosecutions, again, back to the old days in a sense, of having a whole host of senior managers and directors alongside the company in a manslaughter. Now, I mean, that's my own experience, the experience of Chambers. I don't know, Joe, I mean, is that your experience too?
Yeah, similar sort of story and sentiment, Simon. I think I've got a number of investigations at the moment where you've got senior individuals and directors facing the highest level of offence. And I think that's where I've seen the shift more, is that they're going right for that top gross negligence manslaughter charge. It seems to me more than some of the perhaps lesser charges under the Health and Safety at Work Act. But I think I know of 4 this year where during the trial the gross negligence manslaughter prosecutions have failed and the judges had to direct that there's no case to answer. I was involved in one earlier this year in relation to a fatality at Eastbourne Pier, where the site manager and director of the construction company were both prosecuted for gross negligence manslaughter. But 6 weeks into the trial, it was established that the prosecution hadn't provided enough evidence. They hadn't given enough evidence for a reasonable jury to conclude that the defendant's breaches had caused the deceased's death, and that there was no basis for a reasonable jury to conclude that the breaches were collectively gross to reach the level of gross negligence manslaughter. And so rather than having a successful prosecution for gross negligence manslaughter, they ended up pleading to lesser offences under the Health and Safety at Work Act and got relatively low fines. But I mean, the sort of, it was almost inevitable from the outset, but for some reason the HSE, CPS police were determined to get to trial with that higher charge, yes, rather than accepting the lesser charge. And just touching on something else that you said, I mean, the company itself in that instance was fined quite a significant amount, but it's in liquidation, so it's a completely hollow victory. And I think that is definitely an issue that is pushing people to go more towards the directors and senior managers, because of this issue of it's often easier to go after senior managers and directors in smaller companies, but those smaller companies can't satisfy the fine. And I think that you know, after the Hackett review and what's going on with the Grenfell inquiry, accountability and competency are the 2 biggest themes that are coming out of this whole re-evaluation of the construction industry. And that is going to push to wanting people to be prosecuted, as opposed to companies. And actually, I was in the HSE's offices on Tuesday, and the HSE inspector was quite open that they are wanting to get more people actually prosecuted as opposed to companies.
Oh, that's interesting. So taking that a step further, what are the offences that directors and or those in senior positions in companies are likely to face?
I mean, the most serious offence is gross negligence manslaughter, and that is the one that we sort of touched on. And it's, people often say, what is gross negligence? What does it mean? And I think the Court of Appeal last year gave some guidance on it, and they basically said that there are sort of 6 elements that a prosecution has to prove before you can get conviction of a defendant under gross negligence manslaughter, and that is that the defendant owed an existing duty of care to the victim, that the defendant negligently breached that duty of care, that at the time of the breach there was a serious and obvious risk of death. So that's not necessarily what's important there. It's not necessarily at the time of the incident, but at the time of the breach. And serious means that the nature of the risk of death is something much more than minimal or remote. Risk of injury or illness is not enough. And an obvious risk is one that is present, clear and unambiguous. So it's immediately apparent, striking and glaring, rather than something that might become apparent on further investigation. That it's reasonably foreseeable that at the time of the breach of the duty that breach gave rise to a serious and obvious risk of death, that the breach of the duty caused or made a significant contribution to the death of the victim, i.e. more than just a minimal contribution. And importantly, that in the view of the jury, the circumstances of the breach were truly exceptionally bad and so reprehensible as to justify the conclusion that it amounted to gross negligence and required a criminal sanction. So that's what's needed for the gross negligence manslaughter. But as I say, my experience recently tends to be that although we're seeing more prosecutions for it, they're not always successful. What's much more successful often, and the most commonly prosecuted, I think, offence is Section 37 of the Health and Safety at Work Act. And looking at the stats, it seems there's sort of approximately 40 of those a year. And this is the section whereby if an offence has been committed by, if there's been a breach by the company, the offence has been committed with the consent, connivance, or is attributable to any neglect on the part of any director, manager, or a person who purports to act in that capacity, that person as well as the company will be guilty of an offence. That essentially means that a senior person either knew about what was going on or was involved, knew it was going on and did nothing to stop it, or should have known about it and taken action to stop it. And the other one is Section 7, which is the duty on individuals to take reasonable care of themselves and others affected by work. But I think in light of Grenfell, there's also another one that's sort of lesser known section of the Health and Safety at Work Act, which is Section 6. It's the duty of any person who designs, manufactures, imports or supplies any article for use at work to ensure, so far as reasonably practical, that that article is so designed and constructed that it will be safe and without risks to health at all times when it's being used, cleaned or maintained by a person at work. And to carry out or arrange for the carrying out of such testing and examination as may be necessary for the performance of the duty imposed upon him. And whilst I'm not sure that will be particularly used in any prosecutions that come out of Grenfell, because it's very much focused on materials being used in the course of work, I do think coming off the back of Grenfell and the highlight that's been made on the suitability of materials and those that are designing and using materials, and also manufacturers and suppliers of materials, that offence we may see more of that offence coming out in the future. As I say, one of the easiest ways for directors or senior managers to commit an offence, particularly under Section 37, is where they don't respond appropriately to action following an HSE inspection. And I think that actually is often the danger point for directors and officers, and where they can often come a cropper. There was a post-Grenfell successful prosecution this summer of a director called Wayne Braund, who was a director of a company working in a woodwork shop, which was inspected by the HSE. And the HSE issued an enforcement notice, which is one of their powers that they can do to make a company resolve any failings in health and safety. And he failed to deal with that enforcement notice properly, and actually he went further and fabricated documents to suggest that he had. And that case is interesting for two reasons. One, because it involved a fraud and he pleaded guilty, got 6 months in prison, suspended for 18 months, and also was ordered to pay £25,000 in costs. But he also suffered a separate prosecution that ran simultaneously by the fire brigade. And that resulted in a 12 months imprisonment sentence, suspended for 18 months, with a £25,000 fine and a further £25,000 in costs. And I think, again, I have got a couple of matters at the moment where we're looking at an HSE investigation, stroke police investigation, and another enforcing authority, the fire service in my cases as in this case. So I think that's also something that I've seen more of recently than before.
Okay, no, that's really interesting. Thank you. I think if we pause for 1 second and just consider the issue as to who might be covered as an insured person under a D&O policy, and therefore might have the benefit of cover, that probably requires some consideration at this stage as well. It's not just directors and officers, it also includes senior management and often employees, albeit generally speaking, depending on the policy wording, ones which hold managerial and/or supervisory roles, which could be approached by the police and/or the HSE and/or other regulatory bodies such as the fire service, as Joe has just touched upon there. And might face prosecution. It's therefore really important for insurers to consider the policy wording and identify who might be an insured person under the policy and who might benefit from some legal advice at a very early stage. And I think it's then important to consider when the trigger for cover arises under a D&O policy, and that's generally the formal notice of prosecution. But in reality, as I'm sure Simon and Joe will attest to, the process begins much sooner than that, than the formal notice, and the directors and officers and senior managers might be asked, for example, to attend an interview under caution, where matters might be discussed which potentially incriminate the director being interviewed and might have ramifications going forward. So insurers are, and many D&O claims handlers are alive to this, to the fact that if an insured person is invited to an interview under caution, it's likely or reasonably likely that a prosecution might follow, and therefore the need for pragmatism and to recognise at an early stage the need to engage and to recognise that with health and safety prosecutions, there is a need, I think, to spend some money at an early stage. It's not like a civil matter where costs might be more controlled in the early stages. That there really is a need to mitigate the risk at an early stage. And have you got any? I
think that's right. Yeah, that's definitely right, Nathan. And I think there's a couple of things I would add to that. One of which is that unlike often in the civil claims that we deal with, there's, particularly for construction related health and safety issues, there's still a relatively small pool of those experts and counsel that can deal with the construction and the criminal side of it. And so whereas, for example, we might not want to get a QC involved early days on a civil matter, on the criminal side of things, even if we don't want to get Simon involved on day one, we might want to get in reserve because it's a specialist area. And I think that is one of the big differences, is needing to think about your expert, who might be your expert and who might be your counsel at a very early stage, even, as I say, if it's just to reserve rather than necessarily incur a lot of costs at that stage. And I think that things can move very quickly in the first 24-48 hours in a health and safety related incident, and directors and officers need that early legal advice so that they don't set themselves off on the wrong track immediately, particularly when, if there's been for example, a fatality on site. I think people are often in shock, and also there's a human element of always feeling guilty when something terrible has happened. And actually, unless you've got a cold-hearted lawyer in your ear, you might end up expressing emotional responses without thinking about the legal consequences. And it's a very human thing to do, but from an insurance perspective, it's not a great thing to do, because you can end up getting yourself down a path that's going to cost a lot of money when actually you probably don't need to, if you'd had some good legal advice in the early stages.
Yes. No, thank you for that. And Simon, do you have any specific examples in mind where early legal intervention might have been beneficial?
Yeah, well, I mean, quite a lot actually, because very often I get involved far further down the line. I mean, the main thing is interviews under caution. It's the critical point, because individuals and companies that aren't advised properly will often go and attend interviews under caution, thinking that they are going into what is going to be a rational debate with a prosecutor, and they're going to set matters right, and they're going to explain things, and it's all going to be fine. But what they fail to appreciate is that there are agendas at play. These aren't balanced discussions. And very often those that are interviewing are seeking to just go through a checklist of admissions that they want to secure. And once those admissions are given, then the individual is in a difficult position. I mean, particularly in this area. I mean, Joe has set out the offences, but they're enormously wide-ranging. I mean, the Health and Safety at Work Act offences are all to do with risk. And so it's very easy actually to make an admission. It may not actually relate specifically to the incident itself. It's very easy to make an admission of a breach in another regard. And as soon as those admissions start tallying up, then the prosecutors and those that are taking that prosecuting decision will start looking down their checklist and say, well, this has been omitted, that's been omitted, this has been omitted, therefore there are strong prospects of a conviction here. So it's that interview under caution stage. I mean, the number of times I pick up papers, look at the papers and look at what might otherwise be a reasonable defence, because there are proper arguments, but then you look at a raft of admissions made in interview and you think, oh, if only. And equally, the point being, I think, from insurers' perspective is that in many instances, those individuals might not have been prosecutors. The size of the prosecution would have been smaller, perhaps no prosecution at all. Yeah. But it's rather critical to get in early and influence that matter. What we would tend to do in most difficult cases is not attend an interview under caution, and you send either written submissions or you turn up with a pre-prepared statement, read it out, no comment to everything else. Now that sounds cynical, but actually it doesn't gift any of those admissions that I'm talking about, and the reality is you are less likely to be prosecuted as a consequence. So it is quite important to have that advice, because most directors, most managers and most responsible businesses will not think that way. They will expect to turn up and put matters right, and what they don't appreciate is that doesn't all, in fact, very often does not happen.
Yeah, and I think I don't know how many of you were on our first insurance school as opposed to this masterclass, but I mentioned a matter there from 2014 where a young director, essentially the daughter of the owner of the company, who was, I think, made a director but didn't really have any involvement, she ended up in trial, albeit acquitted, for a Section 37 offence, mainly due to the lack of legal representation early enough, which meant that she got bamboozled by the police into seemingly admitting connivance under Section 37, when ultimately she actually had no idea what was going on. So there was no consent or connivance, and there wasn't really neglect either, because she actually had no role in the no active role in the company. But because of a lack of legal advice, there was a huge amount of money spent on her trial, and she was a young 24-year-old girl who, for reasons I still haven't quite understood, faced the ordeal of being arrested, didn't get bail, and had to spend time in jail pending her trial, which you know, is not a good circumstance to be in, and I think was entirely avoidable if she'd had some legal representation in the early stages.
Mm.
Yes. So moving on slightly, Simon, you mentioned your trial earlier in the year, and we've talked about this when thinking about issues that this seminar is addressing. Is that not a perfect example of what you described as the Grenfell factor in your first speech?
Yes, well, I know, because when we were talking about doing this seminar, I did think, well, I think I might have a kind of classic case example of the situation that we're talking about, because The trial I did earlier this year was to do with an explosion at Bosley Wood Mill back in 2015. Now, although the actual explosion itself happened in 2015, the actual key parts of the investigation and the interviewing under caution all took place after Grenfell, and I think there was an element there of a rather confident and hostile team of interviewers, and it explains really the kind of scattergun nature of the charging that they followed. But it probably won't make much sense unless I give a bit of a background to the case. So this was, a massive explosion at a wood mill. It was an explosion of wood dust, which is highly explosive. And in fact, all you need in terms of wood dust, as the expert said at the trial, was about 1 millimetre or 2 millimetres covering across an entire area, entire room in terms of space. And what happens is that if that wood dust gets elevated by an initial explosion and ignition, which may not be that big, but if the shock wave is enough to elevate all the wood dust at the same time, then you just get a rapid explosion of all of that wood dust, which then carries on and blows up and raises more wood dust and explodes and so on. And you have, in a matter of seconds, an enormous explosion. And of course, there's no point in actually talking about that unless you can demonstrate or give an example of that. So I'm going to try modern technology just to show you the scale of it. So if I can.
Okay, what you're about to see, isn't it?
Here we go. I'm sure the technology will fail me completely, but let's have a look. I don't know, Joe, can you see this?
Can see it now. At the moment, we can see photographs, I think, of the, now we can see the photo of the mill.
So this is the prosecution presentation. That's the mill before.
You might need to make it a bit bigger, Simon, I think, because we can see your whole screen still at the moment.
Okay, there.
Yeah.
And so that's the scale of the explosion. Now let me just run that back so you can see it. Those are the 4 people that were working at Bosley Mill at the time that all died. That was the mill before. And that was the extent of this wood dust explosion, which, as you can see, was absolutely devastating. And just to give an example of just how devastating it is, you can just see the rescue attempts there to try to find people and to recover bodies as well. And this took essentially 6 months for them to go through the rubble. This is the drone flyover that took place pretty soon after the explosion. And I think probably better than the plan view gives a kind of indication of the sheer nature of the explosion. It was one of the largest explosions we've experienced in this country in terms of the Richter scale. And all of this caused, as I say, by on the experts' analysis, wood dust being levitated to a point where it could explode. So that was the nature of that explosion. And if I now just show you the actual explosion itself as recorded on CCTV. Again, Joe, can you see that?
Yeah, see that, yeah.
Okay, if I just pause it now, what you're about to see, and I think the most important areas, I can run it back just to demonstrate the point of it, but you have the main area of the mill is over where my arrow is pointing, where my cursor is pointing over here, and you'll see the explosion come from over in this direction too. But what's equally interesting is what happens in this warehouse that's just associated to it, because all of the staining you see here on the walls is actually wood dust. And in a minute, you will see the effect of the explosion, the shockwave that sends, that gives an indication of what happens to the wood dust. The explosion will come from this area here.
Yeah, yeah.
And there you can see the dust coming down off the walls and the ceilings here.
Yeah.
And completely covering this area. So if there was another source of ignition in this area, then that would have triggered an explosion there as well.
Yeah.
So let me get my screen off there. So those are that was the explosion. And as I say, the prosecution case, the experts, was that all you needed was 1 to 2 millimeters. Well, the evidence was that there was quite a bit more than that. I mean, you saw that in that warehouse anyway. But they also had employees who had filmed, who had actually filmed the state of the
Yeah, that's it.
mill beforehand. And this is a video. Can you see this as well, Joe?
Yeah, yeah,
Yes.
yeah.
So this is an employee this is before the incident, who wanted to bring to the attention of the authorities. He never sent this video, but the state of the inside of the mill. And what he was saying on the, I won't play the commentary, but what he was saying was that the HSE, every time the HSE turned up, they would tape off this area so that the HSE wouldn't see the state of it. I mean, you can see there's not just a lot of dust there, there are motors there. I mean, what you're seeing there are all motors that obviously shouldn't be covered in dust. And it infringes by quite some way the suggestion of 1 to 2 millimeters. So that was the nature of the dust that was in Bosley. And the police, when they looked to investigate all of this, they had all of that material, obviously. And they applied a pretty scattergun approach to the interviewing of the suspects. So they interviewed the 2 directors of the company, who were both brothers, the Bowden brothers, and they also interviewed 3 other senior managers, all of whom had to be separately represented, because, and this is a kind of familiar point with these types of investigations, is that as soon as the police apply an approach of going across a whole host of managers and directors, each will have their own position and each is being looked at personally. So in nearly all cases, you'll have to have separate legal representation for those individuals. And at Bosley, therefore, you had to have, it was essentially 4 to 5 legal teams just at the interview stage representing those individuals. And what was worse was that the police decided to have a very open approach to disclosure prior to each interview, which is unusual, but most defendants say, you know, we would like more disclosure before we answer questions at the interview. Well, the police provided an enormous amount of disclosure before these interviews. I think probably because they thought that the evidence was so overwhelming that they wanted to encourage admissions and early acceptance of guilt. And so each legal team had to wade through an enormous amount of disclosure before each interview took place. So the costs had risen, you know, exponentially only by that interview stage in the first place. But what the prosecution did, or the CPS chose to do, was that they only prosecuted in the end 2 senior managers and 1 director in addition to the company. So they prosecuted my client, who was the managing director for manslaughter. They prosecuted the company for corporate manslaughter, and they prosecuted 2 of the senior managers for the offence of section 37 that Joe's referred to under the Health and Safety at Work Act. So those 2 managers were facing potentially 2 years in prison. My client was facing life as a maximum for gross negligence manslaughter, but in reality was looking at probably 15 to 20 years in relation to a 4 fatality incident of this nature and severity. But they chose not to prosecute his brother, Charles Bowden, and that in itself is an interesting issue, because obviously he was heavily legal represented at the interviews. All of the interviews involved representations in writing rather than people turning up to answer questions to them. and the decision was taken that they weren't going to pursue the case against him. So although a scattergun prosecution was involved, it wasn't quite as scattergun as it might otherwise have been, because they didn't choose to prosecute him. And of course, then all the other defendants chose to blame him in his absence because he hadn't been prosecuted. So it was probably a strategic error on the CPS police part. But nevertheless, it was a success, because otherwise that trial would have lasted even longer than it did. And I suppose I ought to just to conclude that kind of the Bosley story is that at the trial, the big issue for all of the defendants was that there was going to be a cutthroat defence. All the directors and senior managers were all seeking to blame each other effectively, and that, you know, that bore out the initial sense in having each separately legally represented at the outset. And the prosecution probably hoped that they would all just cut each other's throats and that would be it. But what the prosecution hadn't realised was that there was a causal argument in relation to the explosion that was open to my client and open to the company. And they hadn't really spotted the implication of it. And we ran it at a submission at half time, at the close of the prosecution case. And as a consequence of that, the judge ruled that they hadn't proven a case of manslaughter because they couldn't prove that the gross negligence that they were alleging against my client or the company was actually causative of the explosion. They couldn't prove beyond reasonable doubt that it was causative. They could prove it was a likely cause, but they couldn't prove beyond reasonable doubt, and they couldn't, importantly, exclude other plausible possibilities to do with incidents that may have occurred actually on the day that weren't attributable to gross negligence on my client's part. So, you know, you put that together, and the judge concluded that they hadn't established their case. So we all went off to the Court of Appeal to argue that, because they argued the judge was wrong, and the Court of Appeal upheld the judge's decision, and we were acquitted of the manslaughter charges in the Court of Appeal that day. And the knock-on effect was that the prosecution then asked whether my client would take a plea to a Health and Safety at Work Act offence, which he did, because he had absolutely no defence to that. The knock-on from that was that they then dropped and offered no evidence against the remaining two managers, because their evidence against them was already rather strained and limited. So at the conclusion of all of that, there was 3 months trial at a Nightingale court in Chester, and that had followed 6 years of investigation. The cost must have been astronomical, and at the end of it, there were acquittals on the manslaughter charges. They dropped the health and safety charges against the other two managers, and the judge could only sentence my client for the Health and Safety at Work Act offence on the basis of a non-causative position, on the basis that it was just a breach that hadn't been responsible for actually causing the explosion, and he got a suspended sentence at the end of that. So, you know, a massive case born out of all of that. And although there was success for the defendants, as one can understand, the cost of the insurers of getting to that point was enormous, and costs that aren't recoverable in the criminal process.
Yes. So, Joe, is it also your experience of there being scattergun approaches to investigations? Yeah,
absolutely. I've got a few at the moment where the HSE in particular, more so than the police, I think, are looking to interview everyone and anyone involved, which is creating a huge amount of statements, and if anything, confuse matters rather than clarifies matters. And worryingly, I've got an example at the moment whereby we went through a round of interviews and information gathering, and we were given a verbal indication that we weren't going to be looked at again. And then just as we were about to close the file for insurers, a different HSE inspector started the merry-go-round again, and we're now going through another round of interviews and information gathering, despite the fact that, much like in the case Simon's just been talking about, it seems to be clear, at least to me, that there are significant issues with the HSE's theory on what happened, and very plausible and I think more probable explanations as to what happened, which would certainly leave room for reasonable doubt in any jury trial, I think, if it's to get that far. But I think that the issue with it is that, coming back round to the beginning of this topic, is that you need to get the legal advice in early so that you can try, to the best extent that you can, control this sort of scattergun approach that they're having and try and put a stop to it as early as you can, and at least be alive to what's going on. If you only get involved later on, then, as Simon has said, you can find yourself with a lot of admissions having been made before somebody's had the chance to think clearly about the implications of what they're saying, especially to HSE inspectors who have you quite often find they've developed their own mission plan that they want to execute, and they will twist things, and they will because the way that it works is that they will take the statement, and so although it's supposed to be your witness's words, it's quite often their interpretation of your witness's words, and it's very hard for a witness to stand up to an HSE inspector about that. But if they've got their solicitor with them, it's a lot easier for that, and that's in the voluntary process. Obviously, when you get to interview under caution, as Simon said, our preference tends to be for written submissions to avoid all of that. But again, without having had that legal advice, you can find a situation whereby your director has already agreed to attend the interview, and then there are all sorts of inferences if he suddenly changes his mind and then doesn't. So again, you want to be in place and have enough knowledge about what's going on to be able to give the right advice as to how to respond for the requests for these interviews, which in the long run should help not get yourself in a very costly trial.
Yeah, I just thought that whilst you were talking then, Joe, that the other point that springs to mind is internal investigation reports as well.
Yeah.
That companies will often do with the very best of intentions, and will probably have to do as well as part of their own health and safety policies. But they probably won't understand that the nature and the way that you set up that internal investigation is quite critical. If you just do it as part of a lessons learning approach, which most of them are, then it's unlikely to be privileged, even if you were to, at some later date, pass it under the nose of the lawyers. And so those reports, I mean, time and time again, I've seen those reports in cases where once we have analysed the situation carefully with experts as part of the legal process, we reach an answer. And then we look at the initial internal investigation report, and it's completely different. It's wrong. It's made a series of admissions that, again, I mean, that's even more so than the interview under caution. You really just can't go against them. It'd be impossible to turn it around in front of a jury for a criminal case and say, well, we're not responsible in circumstances where within 5 days of the incident, your own safety manager has written a report saying that you are. And for individuals concerned, the other aspect of those internal investigation reports is very often, as part of their appendices, they will have the statements taken from various people, or they will record in the body text as what people have said and done. And that can set, a number of hairs running as a consequence. So, that's just another classic example where a lot of damage can be done early on. Again, with all the best intentions, nobody's saying these companies are doing anything wrong at all, far from it. But it's not just a question of giving away things. Very often these internal reports are done under a rush to try and produce a result, and very often they aren't accurate. And that's why it's a good thing not to be disclosing them until you are in a position where you have properly investigated it. But as I say, very often without legal advice, they just won't understand that.
Yeah. No, that's really interesting. Thank you very much. So just returning to what you said earlier about there being a Grenfell factor that may be having an effect, even if only an indirect effect, on the CPS charging policy towards directors and senior managers. Is that just the effect the fire had on the public mood, or is it also the approach that has been taken with directors and senior managers within the public inquiry itself, in your opinion?
Well, I think it's a bit of both. I think, as I said, it's that there's a degree of the public disquiet and, well, to say the least, and also probably more accurately the kind of political reaction towards Grenfell that has caused those with enforcement responsibilities to probably adopt a harsher or more robust approach to corporates and to managers and directors within those corporates. But I also think that the whole process of the Grenfell inquiry and the people being able to go onto the website and watch senior managers, directors of these businesses, and in some cases super large businesses, being grilled as part of this inquiry in circumstances where they may well be the subject of criminal proceedings as well, has really given bolstered a degree of confidence that that is the right approach and that is what we should be doing. And you know, it's always been slightly curious in terms of differences, that where you have financial crime, the frauds and the like, it's very often the case that those in middle management in companies, so, you know, not even very high management, but middle management, and then all the way up to directors, are open for prosecution. And there are a lot of prosecutions that are of those individuals individually, not just for specific acts, but also for policies and corporate policies that have been put into effect. And I think that just doesn't happen with the same degree of regularity at all for health and safety, bizarrely. And there isn't that kind of analysis. And it is very difficult to prosecute, and very few prosecutions have taken place for that type of corporate policy decision making. And it's mainly of somebody that has actually moved the excavator into the individual that has sadly died, or if the director that didn't give the right money for the safety guard, for the guarding of the machine that then caused the incident. So things that are actually specifically involved, but not for that kind of corporate policy. Whereas I think Grenfell's turning that around a bit, and there's a much greater analysis there as to the underlying policy, and it's caused a lot of prosecutors, I think, to think about what they should be doing in those types of circumstance.
Yes. Okay, no, that's really interesting. Thank you, Simon. And accepting, of course, that you can't go into detail as to what might or might not come out of Grenfell in terms of criminal prosecution. Do you think there's anything tangible we can take from the inquiry and the surrounding criminal investigation, which is suggestive that directors or managers may be prosecuted in due course?
Well, yeah, I mean, as you say, you have to be careful that we don't know yet what is going to happen. But the one thing that we do know, and Joe will remember this acutely, is that just before we got into the second stage, effectively, of the inquiry, the first stage was looking at what had happened. Second stage looking very much at why it happened and responsibilities for it happening. And just before that kicked off, there was a big problem, because suddenly a number of individuals who were to be giving evidence, their lawyers said that they were not going to give evidence and they were going to rely on a privilege against self-incrimination. And it transpired from that legal application that they made that actually a considerable number of people had been interviewed under caution by the police, and repeatedly, in fact, on more than one occasion. And so the extent of that and the extent of the numbers that had been interviewed under caution was apparent from the fact that really it would have derailed the inquiry had that application been accepted by the chairman and all of those individuals could have refused to answer questions. You know, pretty much half of the central witnesses in this inquiry would not have been answering questions. And so that demonstrates the number of suspects and people that have been effectively recorded as being suspects by the police. So I think that gave an insight. I mean, what happened in due course was that the chairman actually sought from the DPP an actual immunity for use of any answers given in the inquiry to subsequent in any subsequent prosecution decision or subsequent prosecution proceedings. So in other words, those individuals could now give evidence and have given evidence in the knowledge that nothing they've said in terms of the inquiry could be used against them. Well, not at least officially used against them, but it did, as I say, shine a window into the number and scale of this criminal investigation that's going on behind the scenes, and reveal that clearly a lot of individuals are at least being suspected. And the other aspect of it, which I was touching on earlier, is that one of the more groundbreaking aspects of all of this is a key part of the inquiry has been an analysis and examination of the roles of those responsible for manufacturing the cladding and marketing the cladding, and the marketing claims that were put out and the tests that they were relying on to make those marketing claims. And as I say, normally in health and safety prosecutions, that type of claim, the people that were making it, the policies and decision-making processes that went before it, that would ordinarily be wrapped up in a prosecution of the corporate, the organization itself. The issue, I think, and what will be groundbreaking for safety prosecutions is if individuals are being prosecuted and are successfully convicted in those circumstances, because then I think that will bring it a lot closer to the approach that is applied for financial crime, for frauds and the like. And will open the way for, I think, quite a widening of the number of individual prosecutions that take place as part of these cases.
Yes. No, that's a really interesting insight. Thank you very much. You mentioned earlier, Simon, in the context of the Bosley case, the issue of conflict of interest between directors. Now, that's certainly a regular issue in commercial D&O disputes, where directors regularly turn on each other when there are allegations of fraud, etc. Is this a regular issue in the criminal regulatory context as well?
Yes, because I mean, it's something that Jo was touching on earlier when she was talking about the health and safety executive's approach. It seems to me that, I mean, there's quite a different type of approach that the police and the health and safety executive apply to these types of case. So where there's been a fatality and where the police are still in play, considering whether there's a manslaughter prosecution potentially, they will have primacy for the criminal investigation. And the consequence of that is that they apply quite a different approach, I think, to the health and safety executive, because whilst the health and safety executive take quite a logical, slow, accumulating process, they go and take witness statements from the junior employees, they move up the ranks to the more senior employees, they build a case, a body of evidence and a narrative, and then they choose their suspects from the more senior management, and then they put the various points that have come up to those people in interview. That's the way the HSE tend to operate. The police, on the other hand, are more used in ordinary and orthodox crime to nicking people and obtaining evidence from that process. They arrest people, they search their house, they obtain evidence in that way. And although they don't tend to do that quite so brutally with directors, it's still that same principle, is that they will, at an earlier stage in the case rather than the HSE, tend to say, right, we want to understand what has happened here, and they will arrest or threaten an arrest by gently encouraging the director to attend an interview under caution, and probably at an earlier stage in order to actually understand and elicit information. And that's the approach, in a sense, that has happened in Grenfell as well, clearly, as was given away when, as I say, that application in relation to self-incrimination came out. It became clear that there had been lots and lots of interviews under caution at a time when the Met Police would not have known the full detail of the ambit of all of the evidence that the inquiry was sifting through, because, you know, as I said, that application for self-incrimination came at the very beginning of stage 2 of that inquiry, before any evidence had been called as to as to responsibilities of individuals. So the Met had already been interviewing people under caution long before that, and that's their style. And the implication that has, certainly in terms of the audience here, is that with the HSE adopting that more structured approach, you can work probably more easily under the confines of a single legal team representing the organisation first of all, and then deciding if you need to, or a later stage, to split up representation for individuals, or take a view as to whether there's really a conflict of interest. The problem with the police is they come in so quickly and say, right, we want this director to attend an interview, this director, that you've then got to immediately start getting separate legal representation for those individuals in circumstances where you're concerned otherwise that there could be a conflict of interest. So what it means is it can cause quite a quick escalation of costs, and also introduce a number of legal teams in circumstances where that in itself can bring about difficulties in terms of who's speaking to who, and coordination in terms of just getting instructions as to how you're going to, carry out the company's own investigation. So it does cause quite a lot of chaos and considerable cost as a consequence. But that's the way that the police tend to operate, and that's why these manslaughter investigations can be so difficult.
Yeah, and I see I've also got a different sort of conflict point, which is not a conflict between directors so much as I have a situation where I'm representing one of two ex-directors of a company, because they've sold the company post the incident but pre the conclusion of the investigation, and that's causing all sorts of headaches because the new directors obviously don't want anything to do with it, so they're just open book for the police investigation, and we don't have any control over any of the documents or anything else, and so things are being given over without any context. Records, investigation records, all the sorts of things that we've talked about that are dangerous to be handed over, and it's much better if you can control the context, at least, in which they're handed over. We haven't got, and as a result, thankfully not the one I'm representing, but the other director has just been charged for gross negligence manslaughter, and to be honest, we don't really know what the evidence is that the police have obtained to do that, but because we don't have sight of everything that they've seen from the company, which ordinarily you would have a lot more visibility over if you're still a director of the company that was involved in the incident. So that's another sort of example of where you can get conflicts, where clearly the company is not aligned at all with its directors, and so in effect is aiding the prosecution into the ex-directors.
And also from a practical point of view, for insurers, where there are 2 or 3 or 4 or more directors are covered under the same policy, each having separate legal representation, and given the limits of indemnity under D&O policies are costs inclusive and in the aggregate, it's very easy to get into a situation where you burn quickly through the limit of indemnity just in the very early stages. And there are sometimes incidents where it's very unfair, because you have one director who's taking advice from a very expensive law firm, and you have another director who's taking advice from a less expensive law firm, yet the more expensive director is burning through the limit of indemnity, and that causes issues. And that's obviously one thing where insurers do need to exercise a modicum of control over selecting the legal team.
That's a very interesting point, Nathan, as well, because in Bosley, the other aspect was that we had one insurer who was funding the case for the company and under the D&O, and that insurer funded representation for the 2 managers as well of the company. And when it came to the trial, the 2 managers of the company were in a complete cutthroat blaming process in relation to the director, and therefore effectively also the managing director, and therefore effectively the company. So we were in this rather bizarre position that the same insurer was funding two parties who had, large legal teams who had built up a massive case against the company's interests and the managing director, who were obviously the people that were responsible for taking out the insurance in the first place. So it can result in a quite absurd set of circumstances, but that it is the nature of the way that these things start. At the stage that funding was provided, nobody, I don't think, appreciated how ugly it was going to get.
No. Yeah, a very practical example of that in coming home to roost.
Yeah.
I think we're running out of time slightly. Just one or two mopping up points, and then we have an interesting question from Mark Allen, which we'll move on to. But I just wanted to just mention one or two other things, which is that there are certain policies which obviously covers the corporate entity itself, and for the insurer clients on the talk, they'll be aware that this is usually separate and distinct from the D&O cover, and often with different limits of indemnity and much less scope in terms of the cover available. So where there are allegations against the corporate entity itself as opposed to the individual insured persons, this is something which needs to be looked at in order to sort of avoid any confusion as to cover. And also the need for insured persons to comply with policy terms and conditions throughout the course of the investigations and any subsequent trial. So in particular, it's important to make notifications and ensure that those are as wide as possible. This is taking off the insurer's hat for one moment and adopting a broker's hat, because obviously on policy renewal, the renewal is likely to exclude everything in connection with the notification that went before it, and therefore to avoid gaps in cover, it's important for brokers to really look at the scope of that notification. I don't know whether either of you have any practical experience of that, or any gaps in cover that you've experienced.
Well, I was just going to say one. I mean, I think less so now because I think policy wording's got more robust, but there's always been a bit of a grey area over the fees for intervention issue, and whether that's covered under policies, and the fees for intervention of the HSE's own costs of investigating, which they can claim, it seems to me, just on their own view of there being a breach. They don't have to prove that there's been a breach. And that's now, I think it's £160 an hour, the HSE rate for fees for intervention. So I think insurance policies have got tighter to make it clearer as to whether they're covered or not, but it's always an area in health and safety investigations that comes up as an area for a potential coverage issue. And the other one is something we haven't really touched on because we've been focusing on the sort of actual prosecution, but it's things like cover for the inquest. That can also, I mean, there are some very good reasons why you would want legal. It's in insurers' interest actually to provide costs for the inquest, because again, much like we were saying about people giving interviews before they've had proper legal advice, if someone is left to an inquest, they can face some very difficult questions, and they answer, and then those answers are available. And I think that certainly in the more serious events, legal representation at the inquest can be a cost saving in the long run for insurers.
Completely.
So I think that's something else. Yeah. Sorry, Simon.
No, the only thing I was going to say is that the other aspect with the inquest, and I've certainly had experience of this, is that the police drop out. They say, okay, it's not a manslaughter investigation anymore. So as soon as they've said that, then the inquest can take place. It can't take place until they've confirmed that it's manslaughter. So the inquest then takes place, and then things don't go well in the inquest, and an individual makes a series of admissions or points are taken and a different angle is pursued, at the end of that inquest, if there is a verdict of unlawful killing, which under the new law can now be delivered by a jury on the balance of probabilities rather than to the criminal standards, there's a verdict of unlawful killing, then the CPS will have to review it. They'll have to review the initial decision taken not to pursue manslaughter. And so, and I've had that before, where suddenly what seemed to be a relatively straightforward case went to the inquest, and then you watched another party turn up, not particularly represented, and turn up on their own, and then suddenly it's off to the CPS again. The CPS have changed their mind, and suddenly it's a manslaughter, and suddenly that individual has made a series of admissions. So yeah, it can go horribly wrong at inquest. I mean, I just noticed, I know we're running short of time, but I just noticed, you know, I thought when you did that intro for me, most of which I'm afraid was probably written by me on the website, but the to the Hillsborough case, well, Graham McCrell, who was the club chairman for, sorry, the club secretary for Sheffield Wednesday at the time of the Hillsborough disaster, the club were represented at the inquest, the renewed set of inquests that led to the criminal investigation. And he turned up for that inquest as obviously the key witness for the club. And he was represented obviously by the club's lawyers, but he didn't have separate legal representation of his own. And he did give evidence, as everybody did. And he made a number of admissions during the course of that evidence that were then used as a decision to prosecute him together alongside David Duckenfield at the trial of Duckenfield for manslaughter, you know, a couple of years ago in Preston. And whilst I rather suspect that even if he'd had legal representation, he would have probably still answered some of those questions, the reality is it just demonstrates how those answers in an interview can drag you quite quickly into an interview or in an inquest into a criminal case, and that can happen without you being represented. So I mean, those are rather critical factors.
Yes. Yeah. No, thank you both. I think we've probably covered everything that we wanted to cover during the course of the talk. And as I say, Mark Allen has asked a very good question here. And hi, Mark, and thank you for your question. Do we know anything in relation to HS2 incidents? If I can throw that out to Simon and Joe.
I mean, I know there are lots of incidences, and in fact, I think there was a recent Freedom of Information request done last month, or actually end of September, about the increasing rate of incidents on HS2. I think it's gone up from 48 last year to 64 this year, or something along those lines. But I'm not aware of any successful convictions yet arising out of the HS2 project. That's not to say the HSE aren't investigating various incidences, and I think there's been 8 Riddle reporting incidences as well. But I think it's a question of watch this space. I think one of the things that is interesting about HS2, and also just about the way that a lot of construction projects are done now, is they're often done with JV partnerships and the effect that has on the ability to go after individual directors, because I think that in a JV structure, sometimes they're a bit more removed from what's going on, which can make it harder to establish the facts required that the director or senior manager or whoever has was involved sufficiently enough to warrant a prosecution. But equally, I know that because of the fact that lots of projects are run with these JV sort of hollow companies at the head of them, but they are nonetheless the financial men, that there is a concern, again, a bit like right back full circle, as to hollow victories. Because if you can't go after where it really hurts, which is the sort of big conglomerate JVs, then are you dealing with the accountability issue, which we've talked about? And I think, again, you know, finding a way through to get to the directors of these big JV companies or funds that fund these projects is another area that we may find directors of those sorts of companies coming under scrutiny in a way that perhaps they haven't done before, just because of the way construction projects are procured now.
Well, I can't add to that, Nathan.
That's great. And thank you very much, Joe. And hopefully, Mark, that answers your question. We don't have any questions in the box, but if anyone has any, please do put them in now, or forever hold your peace.
Equally, I mean, we're very happy to deal with them. If you have something after that you want to email any of us, I think our contact details should be somewhere in the information that you've got, or Chloe can put them up at the end, I think, on the slide.
Yeah, absolutely. It looks unlikely that we're going to get any other questions. So that just leaves it to me to thank Simon and Joe very much for their time and the really interesting insight into this. It's been a really interesting discussion. I've learned a lot about H&S investigations, so thank you very much. And thank you to all the attendees. I hope you've enjoyed it as much as I have. And sorry that you had to look at my face for an hour and a half rather than Stephen's, so I apologise. But thank you again for attending, and yeah, if you have any questions, please let us know by email.
Thanks, everyone.
Thank you.
Thank you.